So good evening, everybody. My name is Roshanga, and I will be your host for this webinar. The webinar is one of the series of legal education webinars co-hosted by USA's Co-Justice Project and the Colombo Law Society, with the support of the Colombo Law Society President, Mr. Vijay Gamage, and committee members. Now, I would like to invite Mr. Gamage to take a few minutes and say a few words about the relationship between Co-Justice and the CLS. Mr. Gamage, over to you.
Thank you, Roshanga. Good evening, everyone. I welcome you all to this webinar organized by the Colombo Law Society together with the Co-Justice. I'm Vijay Gamage. I'm the president of Colombo Law Society. Colombo Law Society is the largest branch association of the Bar Association of Sri Lanka, the membership of around 4,000. We are committed to have a strong and an independent bar. We are also committed to enhance the competency of our members, that is to enhance the skills, knowledge, and the attitude of the lawyers. Co-Justice has been assisting us right from the beginning to enhance the competency of our membership. During April this year, with Co-Justice, Colombo Law Society was able to launch a series of webinars with success. I would like to thank the Co-Justice team, especially Chief of Party, Mr. Ken Mortimer, for helping us. Thank you very much. And this webinar is organized by the Seminar Subcommittee of the Colombo Law Society. I would like to thank them, the co-chairs of the subcommittee, Mr. Chatura Galhena and Mr. Sanat Karnaratna, Mr. Nalin Samarakon, Mr. Navin Shanakan, and Mr. Masim Mithyas. They have been working very hard with Co-Justice team. Thank you very much. I especially thank Mr. Chatura Galhena, who is the moderator today. Today, we have two very senior and much respected practitioners as legal practitioners as our speakers. Our moderator will be introducing them. However, I would like to thank them for accepting our invitation and for being with us. Thank you very much. Finally, I would like to thank you all for being with us today, and I hope this webinar will be much use to you. Thank you. Roshanga, over to you.
Thank you, Mr. Gamage. So let me say a few things about the webinar today. The webinar will run for about 60 minutes. The resource persons will have their main presentations. And during this period, the participants' microphones will be muted. This is just to cut out a lot of the feedback that we get when the microphones are on. During this time, you can use the public chat and forward your questions to the resource persons. We will collate them and present them at the question time, where your moderator will pick those questions based on the conversation and the discussion, and then present it to the resource persons for them to answer it. Once the initial presentation is over, the participant microphones will be turned on, where you may directly speak to the resource persons and forward your questions. This whole process, we hope, will take around another half an hour, which will bring us to around 6:30, where we hope to finish this webinar. Now, let me hand over to you to the person who will take you through to the course of this webinar, Mr. Chatura Galhena, who will introduce you to the resource persons for this evening. Mr. Galhena.
Yeah, thank you, Roshanga. Good afternoon, everyone. I welcome all of you to the second webinar of the second series conducted during the second COVID-19 lockdown by the Colombo Law Society. So today's main topic is regarding the family law litigation, where we have divided the area litigation of family law into two main areas, that is the civil suit the district court practice and the criminal aspect of it involved in the magistrates court. The two speakers are two eminent practitioners who are well known. Mr. Chandana Liyanapattabandi, President's Counsel, need no description, but as a formality, I will give a brief description about Mr. Liyanapattabandi. Mr. Liyanapattabandi was enrolled to the bar in 1990, and he's having a practice of over 29 years at present. And his main areas of practice are civil and commercial litigation, starting from district court, commercial high court, court of appeal, and Supreme Court. And family law or actions regarding family disputes, divorce, custody, maintenance is one of his main key areas. And he holds a master's degree in international trade law from University of Wales, and he has conferred Silk in the year 2012, and presently he is an honorary legal advisor to Sri Lanka Cricket Association, and he holds several other positions, and also he was one of the pioneers in the Junior Bar Committee of Bar Association, which he holds the position of chairman of the committee in the year 1999. Mr. Liyanapattabandi has a vast experience in the area of civil litigation. One area he specialized is the family law. Mr. Liyanapattabandi will basically discuss today on the areas practical importance of certain areas that the practitioners must know in family law litigation. Moving to Mr. Samarasuriya, he is an attorney at law, but his title should have changed by now, but he is still an attorney at law. A very sincere friend of ours, and he has been in practice for now almost 20 years. After joining the bar, he worked in the chambers of present president of the Bar Association, Mr. Kalinga Indatissa, and one of the senior juniors of Mr. Indatissa for some time ago. And Ms. Samarasuriya having extensive practice in the area of civil as criminal litigation. He has done a lot of maintenance and domestic cases, having experience, and also gone in appeal in those cases. Mr. Samarasuriya has been the Assistant Secretary of the Bar Association in year 2004 and 2005. He also has been a resource person in most of the activities or the seminars conducted during the past years by the Bar Association. Ms. Samarasuriya also is a practitioner who has vast experience, and he will also join in the discussion to discuss about the civil aspect as well. So without taking much time on introducing and giving a description, I will hand the forum to the two speakers. Today's topic will be, the discussion will be started by Mr. Liyanapattabandi. It's over to you, sir.
Thank you, Colombo Law Society and Mr. Vijayagama is President, my good friend, and Mr. Chatur Galhena, and also Prashanga. Though you are not in the screen, I thank you for getting me involved in this matter. And Ranil, it's a pleasure to be here this evening with you, right? Sharing two different aspects of the law related to metropolitan elections. Yes, I think when inviting me to be involved in as a resource person, I was asked that to discuss much about the practical aspects. That is, because a litigant, would-be litigant, I would call it like that way, would come into contact with you either directly or through their instructing attorney, to a known person. So that I think first of all, you must find out the name and do a search in your diary and see whether you have been, or you have to recollect and see whether you are appearing for the other side, because it has happened to many people when sometimes both parties are contacting the same counsel. And then first thing is you must have a consultation, because the consultation is a must in any case. But here, unlike in a case where involving a fundamental rights application or accident, or like or invoice case where the money recovery case or something like that, here the enormous amount of facts has to be elicited from the client and the clients with other witnesses, so that a proper consultation. And then when you invite them for the consultation, you must make down notes, because when you take down the notes, you will realize that sometimes it may not be for a simple divorce matter. Maybe it involving the children's custody, the alimony, and then various other applications that you can make because due to the conduct of the other party. So that all that will have to be elicited from the mouth of the client. And I, as a practice, I do sometimes, even though they are married and they are adults, I sometimes ask them to come with a person whom we are comfortable with, because sometimes that consultation is needed in attending to this matter, because it's not easy to go for a divorce, because we all know that when we come for this type of consultations, we know that we are going to help one party or both parties to end something called a family. The family is the smallest unit of the society, so that it's not your just a duty just to simply end that by breaking that marriage. You must make sure that you find out as to whether there's a real cause, right? Because we are in Sri Lanka, we can't get the divorces of consent. So, but here, if the marriage is not workable, if it is broken down irretrievably, you have to help them in that case. Yes, say that. When at the same time, sometime when you have the discussion, you will know the client will be satisfied with the legal separation for the time being, because for some reason maybe there are other commitments like with the children, right? So then at the same time, when you realize also, I say in this matter, this is a fit matter for nullity, so that the consultation and getting that information is very important. And as a practice I do is I take down the notes, and also I tell the client, and these are the important areas. These are the important areas in which you have to address, because you have at the moment you have only the marriage certificate or that your birth certificates of your children. But here are the evidence you may require. You may require to give me more proof about the adultery that you are alleging against your spouse. And at the same time, when you say that you are talking about a separation, okay, give us as to why. Is there any cruelty? Whether the cohabitation anymore is impossible? Okay. So let's, under those circumstances, I always tell the client to make a note. I always tell them, you don't have to sign. You don't have to sign, but please make a proper note for us to refer at any time, and then compare that and develop a full complete note. Thereafter we can have we can develop that note as a trial plan, because you know that in other countries, other jurisdictions, it is taught at the law schools itself to have a trial plan, that is procedure under which, I mean, the line of your leading evidence, right? So I always get down that note from the client and improve on that, so that it doesn't matter whether they are computer literate or otherwise. It's best that they take down their own note and give you all the circumstances. And there's another thing I always practice is not to meet the client alone, because in this type of situations, because clients sometimes withheld certain information, for that an instructing attorney before the next date, the junior lawyer, whoever will be able to assist that client to get that relevant information. But of course, we can't get involved in their family disputes. Therefore, we can't help them by finding them facts, because they are to act on instructions. Even if you see, I always say that even at Basu seminars, even if you see the other party at a restaurant with another lady in a way where that your client has alleged is true, you can't come and, hey, I think Ranil, I think it's the way it should be. because other party, we are not there to give evidence on behalf of the party or to find evidence. So that it's always advisable not to divulge that type of thing, because we have come across, we are also in the society, we should not divulge that type of information. We must not. Then at the same time, you know that under three grounds for normal gender marriages, to dissolve a gender marriage entered in the normal gender law, divorce is under three, that is adultery, then what do you call this? Adultery under section 19 of the marriage ordinance. Adultery is one of the grounds. So, but adultery does not happen in a way where we think that your client may not be able to go and follow your other spouse and get that information in a camera, in a video form, or in a camera, in a photo shoot session, because it happens in a way, it's very difficult to get that evidence. But in such circumstances, sometimes the client may ask you, even help them to find a private investigator. In that sense, just introducing is more than enough, and without getting involved in that matter, just merely introducing them and giving them the information what you saw, what you think that might relevant, by following it up and like that. Because even otherwise, even that private investigator or your client may not be able to go inside and get that information, but that other evidence, like information taken from the telephone, using of the telephone, which will lead to the presumption that this relationship nothing but adulterous. So that we can only assist them, but you have to prepare your client. You have to prepare your client. There are difficulties that they will face in going for that litigation. And at the same time, what about if the client comes to you and say that I want to end this marriage because of his adultery, but he goes out, does whatever, and comes home in the evening. He's not leaving me, even though he's fighting with me. He's saying that he's boasting about his girlfriends. He's asking me whether you want to come and see me when my pants are down, but still he's not leaving the house. What can you do? Your client is unable to leave. Your client is unable to leave the home and go matrimonial home, because that is the house given to that client by their parents in their marriage, for their marriage, as dowry, or not as dowry, as a gift. So your client can't leave. In that instances, you may have to advise them what is called desertion and what is malicious desertion, right? So that all that is relevant, and sometimes you're pleading in such a way, because they are in the same house. They are in the same house, but sometimes they want a divorce. Your client wants a divorce. They are not in the same room, but they are in two different rooms in the same house. That is possible. We all know that in the judgment delivered by Honorable Prasanna Jayawardena, the late Mr. Prasanna Jayawardena, he had discussed this. Even the Chief Justice has agreed with that. So they have discussed and find out that the divorce was not permitted simply because the food prepared by wife kept at the table is consumed by the other spouse. So, and even though the intercourse may not happen, there was no malicious desertion, and there was no intention per se, even though they have, for their convenience, living in the separate room. So that you have to gather all that, because it's also happened most of the time. You will see actually the other party is not leaving. The party is inside the house, but asking for a divorce. So that you got to prepare and then say, look, you are not going to your daughter's room, kid's room, just because she is studying. You have to show some intention, even though let the other party be in your house, but at least go to another room, and for the sake of the law, because the law will require you to prove that that there is no cohabitation between and there is no possibility that the marriage will commence in a normal way. So that you've got to give some strength to your client to find out that material that is necessary. It's not easy to end a marriage because there are children involved, but still, if they are not prepared to cohabitate any longer with good reasons or bad reasons, then the lawyer's duty is to make sure that they end that in a peacefully and a very legal manner, in a very dignified manner, without harming their children's future. Because so that then we have to find out whether the children are of what age, whether how it would, even though we are not the doctors per se, we have to find out whether that will affect the children and how we can advise the client that and as to how they can secure their future, because education and well-being can be dealt with under the Civil Procedure Code. It says that the district judge before whom is pending can deal with all that, so that at either at the order nisi stage or even after the order absolute was made. So we got to advise them, and sometimes you will see that the client would say, no, I don't want anything from the other spouse. I only want the divorce. I only want the peace of mind. Yes, but please make sure that, because there are, not that I'm saying that the clients are bad, there are instances where the clients are going back on their instructions. So that is why I tell you that to prepare that note, have proper communication, keep those copies of your communication in your brief intact until the final end of the matter. Because sometimes they would say, no, I have asked for it, my lawyer had connived with the other side and did not get me this relief even though I wanted. So that, and at the same time we will also tell them that your property that was given, written in the name of the other spouse by your parents in marriage, those things cannot be dealt with in this divorce matter unless there is a settlement on property matter, because those are not coming in the purview of the Civil Procedure Code. The Civil Procedure Code only deals with the different elements of the matter. May I also, because I want to emphasize that matter, because you would see in almost all of these divorce cases, we deal with everything. We say that because, one second please. Only the one second. Yes, if you see section 609, because after the dissolution of the marriage, other parties' property become separately held. Then section 615 is the utmost important. If after discussing about the after alleging grounds, as Civil Procedure Code requires, after alleging the ground for the divorce under circumstances, you have to ask only what is there in the section 615 other than the divorce. That is, divorce order for the benefit of either spouse or the children of the marriage of both, that the other spouse shall do any and one of the following things. That is, conveyance or settlement as the court thinks reasonable of such property or any other thereof, as part thereof, or as he may entitled to. Pay a gross sum of money. Pay annually or monthly a sum of money as the court thinks reasonable. Secure the payment of such sum of money as may be ordered under paragraph B or C by the hypothecation of immovable property, like that. So you will see that therefore these things will have to be very clearly dealt with in your claim. And at the same time, how if your client is not living as the law requires in Colombo, in Sri Lanka? How if they are living in other country, like we'll say, just for the namesake, I would take the word Dubai. How if they both are living as had been living as husband and wife in Dubai, and they still want to get the divorce under the Sri Lankan law? My advice would be, this is not to enforce a contract, that is to end the matrimonial relationship. Therefore, the Sri Lankan courts will not have, because you will come across this situation many times. The clients are coming and saying that they live abroad, they contact you by international calls and tell you that you want a divorce. But can the Sri Lankan court grant a divorce? No, because Sri Lankan courts have no jurisdiction over people living in other country and as husband and wife in that country, because the spouses leave in the morning from Dubai and come into that is what you call domicile. They return to that home. So they have left, ending that matrimonial relationship from that home. So that what happened in a different geographical location, can that be resolved by a country? Just because in Sri Lanka they have entered into the marriage? No, because they are not amenable to Sri Lankan law. So that you got to advise them to seek advice from the lawyer of that jurisdiction and see what relief that they can get under that law. It is always they try to come to Sri Lanka and get a divorce because sometimes because in certain other countries jurisdiction they say always no, 50% you can get the marriage divorce, but you have to share all your wealth accumulated or earned after the marriage 50-50. So that to avoid that, sometimes they try to get the divorce and try to take it abroad and try to enforce that. No, you all know that one NLR case, Lemasuri vs. Lemasuriya, it has already decided that the Sri Lankan courts have no jurisdiction over people living in another jurisdiction. And by operation of the law, that is our grounds, when the Sri Lankan courts to take cognizance of those grounds, these things must happen within the jurisdiction of that court. So you then might ask me, well, how if one party returns to Sri Lanka and coming under civil procedure and then try to file an action? I say no, because still their matrimonial home was where they have had their residence as husband and wife. You all know that, because I wanted to emphasize on this matter, because matrimonial domicile is decided already. If you come across any copy of Black's Law Dictionary, you will come across all these definitions other than the books that I am going to mention. Matrimonial domicile is the domicile that a husband and wife as a married couple have established as their home, right? So that where they, when they were living as husband and wife, leave in the morning and come in the evening with the dawn of the sun. So this is so that you got to advise in such way. No, Sri Lanka, we can't take this law into our hand and file actions like that, because we know we can't help you to file actions by breaking the law. But at the same time, I have already mentioned that, as you all know, in Sri Lankan courts, Sri Lankan law does not recognize the no-fault marriages. That means without alleging the fault, that is on the grounds of, as section 19(1) says, of that is malicious desertion, incurable impotency, and adultery subsequent to the marriage. But sometimes people might ask you, we both want to end this marriage, but since we can't get the divorce of consent, we got to discuss with the other side lawyer. We have to tell the spouse who comes to you, get your lawyer to appoint somebody, and we'll see whether we can get something called, no, not the no-fault divorce, but with divorce without without contesting with each other's case, right? So that is. But sometimes I come across, I think we all have come across situations where people come in and say that, you know, I was not here in Sri Lanka, but because then other party has got a divorce without even serving summons. So better to, sometimes people try to advise the clients by saying, no, don't file your, we will file the plain, you take the summons and don't file the proxy, or don't file, after filing proxy, don't file the answer. I think that's a very bad practice. Never encourage that type of practice, because there'll be repercussions. How if the client goes out from you and retains another lawyer one day and say, I don't know, I have not been served with the summons. How can it be? They can come and say, alibi, I was not here in this jurisdiction. I was in Hambantota. So that it's always advisable in a situation like that, since of consent you can't get the divorce, but you can help them to peacefully go out from each other's life, asking them to appoint lawyers and file plain and the answer. But when they come to the case, retain a lawyer and say that we are not contesting other side's points. So that is called, we allege in the plain and the answer very nominal grounds, very little things, that even though we have other things to say. And at the same time, I also something else, that is in the plaint, when the other party files a plaint, you also want to get the divorce, but not, you are denying the grounds alleged by your other side, but you also want the divorce. You are the defendant in the action. You are advising the defendant. Here, the section 603 indicates that situation and allows you to do that. But this is not to be taken mistakenly as claim in reconvention. Claim and reconvention, as indicated in section 72, 75 of the Civil Procedure Code, is for different purpose. Here, the specific provision has been made in the Civil Procedure Code called section 603, so that always after denying all that what is there in the plain, reiterating all that, and then start with a subheading. That's my suggestion to you. That is to start by saying the defendant entitled relief as envisaged in section 603 of the CPC. Civil Nadudana Sangrahaye 603 වගන්තියෙන් අදහස් කරන පරිදි විත්තිකරු විසින් සහන ලැබීමට ඇති අවස්ථා. I think that would give a very good pleading for the judge even to lead. And may I also take a little time to just say one more thing. It's about the other than the divorce, there are things called nullity and separation. Section 607 and 608. So that section 607 talks about null and void. That means you go to courts and get it null and void. So the Roman Dutch law principles that are applicable to, because that say envisage the law applicable to Sri Lanka, so that the Roman Dutch law ground will have to be asserted after consultation and pleaded. And section 608 alleges two different ways of separation, and there was a discussion as to whether after 7 years you still have to allege the grounds for divorce. No, you only have to merely say that the time has passed and we have 7 years have passed, we have had no cohabitation, and there is no intention to come back to cohabitation, and therefore please end this marriage. Right. I think that is for the time being, unless our moderator wants me to address something else.
Sir, yeah, we'll come back to you when with the questions. Since the time restriction has to be adhered.
That's
Thank
what
you for the brief discussion on the basic area of civil litigation, and we'll come back with the questions, sir. And now I will move into Mr. Samarasuriya to discuss about the magistrate court proceedings in maintenance and domestic violence actions. It's over to you, Mr. Samarasuriya.
Thank you, Chatura. Good evening, everybody. First of all, let me thank Colombo Law Society and also President Mr. Vijay Gamage and my good friend Chatura Galhena for getting me involved in this program. And Mr. Chandali Department President Council, it is indeed a pleasure, nothing but a pleasure to be with you or share this program with you as a resource person. Having said that, I'm told, or I was instructed to speak to you all on the practical aspects of maintenance applications and applications made to prevent domestic violence. And we all know more than the domestic violence applications, maintenance applications are very common applications that you find in a magistrate court. And the sympathy of the judges are more, of course, with the applicant in applications of this nature, but that does not mean that they will give you everything that you ask merely for the asking. As you know, there is an applicant when you go before a court and ask for certain reliefs, you have a duty, you have a burden to satisfy court that you are entitled to the relief that you have sought. So it is only once you prove that, establish that, the court will be in a position to give the reliefs or grant the relief that you have sought. So as Mr. Lina Padapan said, the initial consultation is very important for that purpose. It is not so only with the applicant, it's the same when you're appealing for the respondent as well. Because when you're appealing for the respondent, you, after having gone through the pleadings that have been filed by the other party, you will have to decide based on the circumstances of each case, what defense are you going to take up to deny or contest the relief that has been sought by the applicant. So whether it be the applicant or the respondent, first consultation is very important, and please take time to speak to your client and collect all the information that is required to prepare your client and also to prepare yourself properly and adequately to meet your case in court. And I will first discuss with you all about maintenance cases, mainly about the practical aspect of maintenance cases. But before I proceed any further, I will just draw your attention to Section 2 of the Maintenance Act. When one goes to the Maintenance Act, Section 2 in particular of the Maintenance Act, you will find that the matters that you need to establish on behalf of an applicant, and also the matters that you need to meet as a counsel for the respondents are well set out in the Section 2 of the Maintenance Act. And may I, for your assistance, read Section 2, which will also make my life easy in proceeding with what I have to tell you. Section 2, Subsection 1 says, where any person having sufficient means neglects or unreasonably refuses to maintain such person's spouse who is unable to maintain himself or herself, the magistrate may, upon an application being made for maintenance, and upon proof of such neglect or unreasonable refusal, order such person to make a monthly allowance for the maintenance of such spouse at such monthly rate as the magistrate thinks fit, having regard to the income of such person and the means and circumstances of such spouse. So you will see the discussion is with court in deciding how much should be awarded as the monthly allowance to the applicant. And it is your responsibility as the counsel appearing for the applicant to demonstrate to court that the respondent that you have named is a person who has sufficient means and that he has unreasonably refused or failed to maintain the applicant. And in order to prove that he has failed or the respondent has failed, you will have to first establish in court what you require on a monthly basis to maintain yourself. More often than not, we find applications are being made with very hypothetical figures as being sought as maintenance. And when you have hypothetical figures which are far from reality, you will find it difficult to substantiate your claim in court. And more than you, your client will find it difficult under cross-examination to satisfy court that she in fact incurs that amount of money as expenses for their maintenance. So without putting in just a figure, I think what the first thing that you should do is you must get your client to give it to in writing if possible the expenses that she requires or the expenses that she has to meet for a month with figures. For example, every person will need food for their living. So there will be a certain amount of money that will be required by every applicant to meet this requirement. So it is not you who will know the actual expense on food of this particular applicant. So you will have to get your client to indicate to you how much he or she spends on a monthly basis for food. And get your client also to collect whatever proof that she or he can with regard to the expenses that she makes to purchase items that are required or the food items that she purchases for a month. Because when you go before court, it's not only that you have to be practical with the figures, but you need to have proof. In maintenance applications, you will not have evidence for each and every expense that you do for a month. But there are certain expenses for which you will invariably have receipts. And if your client is a person who generally purchases provisions for the month from a supermarket, obviously there are receipts that have been issued by the supermarkets when you purchase goods. So instruct your client to collect those bills. But if it is a person who has been purchasing goods from a Sunday puller or from a public market, probably it will be difficult for your client to collect proof or receipts for whatever the purchases that they have made from these public markets. But ask them to make a note of those expenses so that they could indicate to court in their evidence with regard to the expenses that they incur as food. Likewise, there will be other expenses, purchasing of medicine. Then, if it is for the children, there will be food. Then there will be other expenses for education activities. Then for medical, there will be medical expenses. If the children are schooling, there will be charges or expenses for transportation. So those are proof that one can collect. And you have to be realistic with the figures. So you will have to get your client to give you in detail of the actual figures in relation to the expenses that they incur for a month. And if the application is being made on behalf of for the mother, the lady, as well as for one or more children, see that you prepare this note for each of those members separately. So when you lead evidence, you can always lead evidence separately and satisfy court that so much of expenses or money is required on a monthly basis to meet or to maintain each of those persons in respect of whom the application is made. And when you do so, the court will be in a better position to grant you the relief that you have sought. And also, you will have to find out from the client the social status that they have been enjoying or the facilities that they have been enjoying whilst you were being maintained by the party, by the respondent. Because the respondent has a responsibility to ensure that he maintains, if it is the wife, the spouse, in the manner that he has been maintaining her from the beginning of the marriage. So, a person who has been traveling to, let's say, to workplaces in a car is entitled to ask for expenses to travel in a vehicle as maintenance. But a person who has been traveling or using the public transport cannot ask for expenses as transportation cost to travel in a car, because that is not what the law and the court would expect or would want to give to maintain yourself. So firstly, you must ask and you must know as to what kind of a lifestyle that they have been enjoying, the spouse or the children, and must get all details that are required or relating to the expenses that they incur to maintain that lifestyle. One need not cannot go one step higher or even lower. All what you have to do is get these information from your client, and it will make your life and the lives of the client very easy. In few matters where I took over halfway through, or where instances where pleadings were not done by me, I have found it difficult, and so had been the applicant, to justify the figures that we have asked or sought in the application. So I don't think you or your client should go through that, because when that happens, the court will not be inclined to grant the relief that you have sought. So most important thing is you need to satisfy court that you are entitled to the relief that you have sought, and in order to do that, you need to get proper instructions with regard to the actual expenses, and please ask only for the actual expenses as relief, and also to satisfy court, make sure that you collect or instruct your client to collect every possible proof that he or she can collect. And then, having done the first step, the second step would be to demonstrate to court that the person who is not maintaining or who has failed or refused to maintain you is a person who has sufficient means to maintain the applicant. The fact that he has so much of assets or wealth is insufficient, or is not the requirement that the court would look for in a maintenance application. What you need to show is that he has sufficient means. So if he has assets, I think what you should do is, if he's deriving an income out of the assets, let's say if he has an estate, the fact that he has an estate will not take you much anywhere, but the income that is generated from that asset, from that estate, is a thing that matters in an application for maintenance. Because that's an income, those are the means of that particular person, the respondent. The salary, the rent that he may get from a house or a shop that he has given on rent. So likewise, if he has all kinds of income that he has, are the matters that will be important to you to satisfy court that the respondent has means to meet your expenses or the maintenance. So in order to do that, you have to have a chat with your client and see what kind of a person is this respondent. Is he a person who is employed and getting a monthly salary? Then of course matters will be very much easy for you, because all what you have to do is, even if you do not know his salary, the actual salary, and even if you do not have proof of his salary, all what you have to do is to call a witness from the company or from the institution